Hi guys, welcome to my channel once again. This is Batopithola. My name is Misjoining, and this is the day that the Lord has made for us to talk about charges on this channel. Yes, today we're going to be talking about charges. What have you heard about charges? I'm sure that if you're a law student, you've heard a lot, and if you're a lawyer too, you have heard and experienced a lot. And if you're a layman, today is the day. Even if you've never come across charges, you are going to learn all about charges, what a charge should contain, what a charge is first, then what it should contain, and how it affects, the case of the prosecution, and how it affects the accused person, the defendant, before the court in a criminal matter. So let's get right into it, but don't forget to subscribe to this channel if you have not subscribed, and please like the video after you've seen it if you loved what you saw, and by all means leave me comments in the comment section. I will be reading them all and responding as necessary. Let's talk about charges. A charge is the statement of offense with which an accused person is brought before the court. Essentially, a charge is a statement of the offense or offenses that an accused person is charged with before a court of law. The importance or the necessity of a charge is to inform an accused person of the case against him before the court of law, to give him adequate notice of what the court or the law or the prosecution has alleged that he has done, and so as to give him adequate time and opportunity to respond to it, to prepare his defense, and to defend himself before the court of law. The charge must contain sufficient particulars to give the accused person a clear idea of the case against them and their involvement in that case. It's important for a charge to disclose particulars of the offense and how the accused person is involved in it, so as to prevent or preclude a miscarriage of justice, and to ensure that justice is done and the accused person is not shut out or witch hunted or punished unjustly or wrongly. So the charge on the face of it must disclose what the accused person has done, to whom he or she has done it, and how it constitutes an offense. That is to say that an accused person can only be charged with an offense that has been codified, an offense that is written down as a law, not just wishful thinking or moral wrongs. The offense must have been criminalized and codified in the laws of the state, and that's the only time when it suffices to bring an accused person before the court to answer to it. So that's what a charge is basically. It's that statement of offense, usually reduced into writing, typed out, printed out, which brings the accused before the court of law. There are some very important things that must be contained in a charge sheet, and they are very important. When you look at a charge sheet, whether you're a lawyer, a law student, or a layman, when you see a charge sheet, there are some things that must be on the face of it which gives it validity, and those things I will look at some of them in more detail much later, but as of first instance, let me mention some of those things to you. So when you're holding a charge sheet, these things should be there to show you that it is proper and it's sufficient to bring the accused person before the court to answer the case against him. The date of the offense, the time of the offense, the name of the accused person, the offense that has been committed as codified by the law, and the name of the law officer that drafted the charge, his signature, and the date must be contained. Of course, the heading of the court before whom the accused person is brought must be included, and it must show who is charging or bringing the accused person before the court. If it's the police, it must show you COP and so person, that's the accused person. If it's the attorney general now at the high court, it must show you the state versus or and so person, just to show you the person, the authority that has brought the person before the court. I will be talking in more detail about an information. An information is a charge at the high court. At the magistrate court, it's called a charge. But when it gets to the high court, it's called an information. So I'll be talking more about it because that's my area of specialization. I hardly go to the magistrate court. As a prosecutor, my jurisdiction is the High Court, and that's why I'm talking about the High Court in this video. And at the High Court, the state files an information. Section 109 of the Administration of Criminal Justice Act 2015 empowers the Attorney General, to bring an information before the court, before the High Court. So the Attorney General is empowered, and so are officers under him, to institute criminal proceedings by filing an information. Now, there are some vital documents that the information must be accompanied with when it's being filed in the High Court. And those documents are in totality called the proof of evidence. So when you hear proof of evidence, this is what it contains. 1, the statements of the defendants or defendants, whatever number they are. And then the statement of the witnesses in the case. Usually, you know that witnesses would have given their statements at the police station. That's when the case is still at the police station before it's charged to court. So the statements of the defendants, the statements, I'm saying statements because a defendant or a witness could make more than one statement. So the statements of the defendants, the statements of the witnesses in the matter, the list of witnesses that the prosecution intends to rely upon in proving its case before the court, the list of exhibits. Exhibits are things, material things that the prosecution usually relies on to prove their case before the court. It could be, the weapon or the implement or machinery with which the crime was committed. For instance, if a person was hacked to death, the police could recover, the machinery with which, the accused person or the defendant, hacked that person to death. That's an exhibit. So it could be monies recovered at the scene of robbery or from robbers arrested by the police. So those are exhibits. So list of exhibits, that's 4. And the 5th thing is any other document in support. So those things are called proof of evidence. So when filing an information before the court, the proof of evidence must be attached. That is to show the court that the charge or the information is not frivolous, that the prosecution has done its own work and is able to sustain the charge and prove its case against the defendant in the court. Now, let me say at this point that there's a lot of drama surrounding charges, especially if you're a law student. When you get to the law school, it's one of the most hyped and, one of the most, seemingly terrifying topics in law school. But I would say that, as much as you read, matter of fact, when you read your textbooks in law school, they would give different opinions and, different directions as to charges, what they contain and how they should be drafted. Now, agreed, charges are drafted in different ways at the magistrate court, at the High Court, and in the North and in the South. But I've told you earlier on this channel that whatever I talk about, I'm talking about the Southern Nigerian practice of law. That's what I'm talking about because that's where I practice. So you should avert your mind to that as regards whatever I say on this channel, except that I have qualified it differently. So there are so many varying opinions and positions regarding charges. I wouldn't like to go into the details of that because it will take all of our time and, there wouldn't even be sufficient time to, explore them. And even more so because, the law school syllabus and, agreed positions keep changing year in, year out. So I would say that you should read your textbooks and listen to your lecturers. So whatever they tell you is the final position of the law school for the purpose of bar finals. If you're a law student, that's the official position. But in this video, I'm going to try as much as possible to dwell on general positions that are generally agreed wherever you go. So I'm going to be talking about information in the High Court, and now I'd like to talk about what it contains and how it is drafted. And I would like to say that this is law school standard even, because in practice nobody drafts it this way. I would have loved to show you a copy of the chart, the way we drafted our work, but it might cause confusion because it might vary in your state if you're a lawyer or if you're a law student or if you're a layman. But let's talk about, the basic features so that when you see a charge, no matter how they've styled it or the method with which they've drafted it, you would know that, oh, it contains this, it's a valid charge. So we'll just stick to that. So the charge must contain the statement of offense and the particulars of offense. There are some positions of law that says that statement separately, particulars separately, and some just lump it together. In practice, where I work, we lump it together. But you know, when you read your law school textbooks, they would separate it for you. So whichever works and whichever gets you the grade that you're looking for. But in practice, they are lumped together. So essentially, an information now at the High Court must contain the statement of offense and the particulars of offense. The statement of offense simply shows you the name of the offense and the punishment section. Never forget this principle. Whatever you take away from this video, I think the most important thing is for you to know that crimes are punished or charges are drafted based on the punishment section. For some offenses, there's a different section of law that explains the offense and its ingredients. But there's a different section of the law that talks about how it is punished, however it is carved, or however it is drafted in the law. A charge, a count, each count of a charge must be drafted according to and based on the punishment section. So even if the charge, the count in the charge sheet has told you, the section where you find the offense, it must also, as a matter of compulsion and necessity, it must show you, the punishment section, because that's where it derives its power to punish the offender or the alleged offender. So that said, an information must contain the statement of offense and the particulars of offense. Now, the statement of offense contains the offense, the name of the offense. If the offense has no name, according to the law, it must be described in such a way that you will know what offense they are talking about, even if the law has not given it a name. So the name of the offense and the punishment section, that's what's contained in the statement of offense. Now, the particulars of offense. The particulars of offense contain, the name of the accused person, the date the offense was committed, the time the offense was committed. That's the time of day. Very important. I hope that after this video, I'll do a video, looking at, a form of a charge as drafted already. So maybe we will talk about why some of these things are very important in more detail, because drafting an offense and putting the time of day it was committed is very important, because it could totally change the flavor of the offense. For instance, I'll give you an example. For instance, when you look at the offense of burglary, breaking and entering. Breaking and entering happens during the day, but burglary happens at night. So if you omit the time of offense, it could change the flavor of the offense. Now, for breaking and entry, according to section 411 of the Criminal Code, it's 7 years imprisonment. But for burglary, it could attract life imprisonment. So if you omit the time the offense was committed, it could literally change it from a capital offense to a non-capital offense. So that's why it's important. So you could form an acronym for this if you need it for exam purposes. But essentially, the particulars of offense must show us the name of the suspect, the date the offense was committed, the time of day the offense was committed, the place where the offense was committed, the name of the victim of the offense, and the nature of the offense. Those are particulars that show us, what type of offense it really is. That is, oh, you broke into so house and did this and that and that and that. Those 6 things must be contained in the particulars of offense. Whether you've lumped it together or you've separated it depending on where you're drafting from and under which criminal procedure rules or code you're drafting under, it must contain these things. So that's it. I'd like us to talk about the 4 cardinal sins of drafting charges. Very important. They will shed more light on some of the things we've already talked about. And please put your mind to it. You could form an acronym for it as well if you need it for exam purposes. They are basically the rule against ambiguity, the rule against duplicity, the rule against misjoinder of offenses, and the rule against misjoinder of offenders. Let's get to it. Before we go further, I'd like to say that most of these rules or cardinal sins have exceptions, and the exceptions vary. And there are, several decided cases that are supporting them. So if you need, to understand those, you could do some further research but let's talk about the things that can help you, understand a charge at a cursory glance. The first is the rule against duplicity, and it simply says that one count, one offense. So you cannot put more than one offense in a count of offense in a charge sheet. That count one must contain one offense. If there are several offenses that the accused person or persons have committed, you have to list them out in counts. So do not lump offenses together. Offense number 1, count 1. Offense 2, count 2. Offense 3, count 3. Offense 4, count 4. Like that. So that's the rule against duplicity. Do not put more than one offense in a count on a charge sheet, except the law permits it. That is, except the offenses are conjoined by the law. So if they are not conjoined by the law, you cannot join them together. So that's the rule against duplicity. The second is the rule against ambiguity, and that just shows you that your charge sheet, the charge against the accused person, the counts of the charge sheet must be simple and clear enough to give the accused person a clear picture, a clear idea of the offense that they are being charged with. They must understand it on the face of it. So a layman, the Clapham omnibus man, and the accused person themselves must be able to understand the charge against them. There must be no ambiguity in drafting. That's the second rule. That's the second cardinal sin, the sin of ambiguity. It's not condoned at all. The third is misjoinder of offenders, and that rule and that sin is the sin of joining offenders together. In a charge sheet, offenders cannot be joined together. Each man must bear his own iniquity. So that means that you cannot join offenders together. There are some exceptions though. For instance, the crime of conspiracy. Conspiracy has to involve two people or more. So if they have conspired to do something together, they can be charged together in one count. But aside that, and some other exceptions provided for by the law, ordinarily, offenders are to answer individually for the crimes they have committed. They are not to be lumped together in counts in the charge sheets. And the last rule is the rule against misjoinder of offenses. And that means that distinct offenses must be charged separately. That is, a distinct offense, a distinct count on a distinct charge sheet. So offenses cannot be lumped together except as provided for by the law. For instance, where a person commits several crimes within 12 months, at least 3 of those crimes can be charged together on the same charge sheet in different counts. 3 of those crimes can be charged together in the same charge sheet but in different counts. Also, where the accused person has committed different offenses in the same transaction. For instance, an accused person has gone to kill someone, murder someone, and in the process they robbed the person alongside. So robbery and murder can be charged in the same charge sheet but in different counts. So aside that and some other exceptions provided for by the law, which you might need to look into if you're using this for exams purposes, the offenses must not be joined together. That's the rule against misjoinder of offenses. Those are the 4 cardinal sins of drafting charges. Please pay attention to it. Once you understand these things, they will help you understand how charges are drafted, and they will help your knowledge of charges, whether you're a layman, a law student, or a lawyer. Now let's talk about amending charges. So there could have been mistakes, or there could have been defects in a charge discovered even after the prosecution has filed the charge. Charges can be amended. Now it's important to note that a charge can be, when I'm talking about charges here, I'm still talking about information. It's just the nomenclature that differs based on the court. So at the High Court it's an information, but it's still a charge anyway. So charges can be amended at any point in time before judgment. That's the law. Don't question me, question the law. I would wonder why you'd allow the prosecution to come before the court and amend charges even on the day the judgment has been fixed. If the plea has not been taken, a charge can be amended without leave of court. But where the plea has been taken especially if it's a fundamental defect. Leave of court has to be sought and granted before the charge can be amended. Now, charges can be amended for various reasons. It could be for minor reasons such as typographical errors, or it could be, for fundamental reasons that go to the root and substance of the charge. But essentially, let me list out a few cogent reasons why you could amend charges. Where the charge is defective, it can be amended. Where you seek to substitute or add an offense, charges can be amended. Where you seek to, add or remove an offender or an accused person, charges can be amended as well. And where you seek to withdraw the charge altogether. Now, you have to prove a few things before the court where you're asking for leave to amend your charge. And these things, I'll give you 5 of them, which you have to prove before the court. If you recall the video I did on drafting motions, we drafted a motion for amendment of a charge sheet. So if you remember it very well, I advanced some of these reasons. Now you have to show the court or prove to the court, that's in your affidavit, in your supporting affidavit, that the defect is curable. That's one. That the amendment will not offend or oust the jurisdiction of the court. That's 2. And that, the amendment will not occasion a miscarriage of justice or injustice to the accused person. That the amendment is not frivolous, and that even after the amendment, the charge is still sustainable. That is, the proof of evidence before the court is sufficient, and the prosecution can prove its case before the court even after the charge, even based on the amended charge. So those things you need to prove to the court in your affidavit in support of the motion for amendment. And so when you're bringing a motion for amendment before the court, it's motion on notice, and you attach an affidavit in support and a written address, which could be done orally if you prefer. But a motion on notice must be accompanied by an affidavit in support, where you would, make reference to the exhibit, that's the proposed amended charge, which you would attach to the motion as well. So that's how to amend the charge before the court. There are 5 things to note. The first is that you need to read the charge to the accused person all over again, and they have to take their plea again. That is, they have to consent to being tried based on that new offense or amended, charge. So the plea has to be taken again. After the plea is taken, you ask the accused person. The second thing is you have to ask them if they are willing to proceed or if they'd like to adjourn to better prepare a defense because of the amendment, that has been occasioned by the prosecution. So if they want to adjourn, the court has to give them the adjournment once it's justifiable. Or if they want to proceed, they can proceed. That's 2. The third thing is that the court would have to endorse the order of amendments on the amended charge. The fourth thing is that both parties are actually entitled to adjournment if need be. Both parties, the prosecution, the defense, they're entitled to adjournment if they need to, go back home and prepare their cases before the court based on the amended charge. And the fifth thing is that the accused has a right to call other or new witnesses or recall witnesses that they've called before, because the charge has now been amended. So those things must be put into consideration. I'll try to do a video, showing you a real charge, a prepared charge sheet, and what it really looks like, in practice. I hope that it would, provide more light and, give substance even to this earlier video that I've now made. Thank you for watching so far. If you watched to this point, you are the real MVP and I celebrate you. So make sure you subscribe to the channel. Make sure you leave me comments. Let me know what you think of the video. Let me know what it has taught you. And let me also know what you'd like to see more of on the channel. Share this video with your friends. And I will always see you in my very next video. Toodles!